The judge's voice cut through the hushed courtroom at the Downing Centre, crisp and unequivocal. The conditions imposed were not reasonable. A collective exhale, barely audible, rippled through the small group gathered, their eyes fixed on Siena Hopper. For weeks she had lived under a cloud. Her movements restricted, her sense of freedom deeply compromised. But in that moment, in the heart of Sydney, a cornerstone of Australian justice, the right to protest, the presumption of innocence, was reaffirmed. This wasn't just about one young woman, it was about the delicate balance between public order and the individual liberties that define our democracy. It was a stark reminder that even when the state acts, it must do so within the bounds of what is fair and what is lawful. Siena Hopper at 25 was not what most people would picture when they thought of someone facing a court battle. She lived in a shared house in Marrickville, a vibrant inner West Sydney suburb, working part-time in digital media, navigating the familiar challenges of rent and rising living costs. Her life before this incident was typical of many young Australians, a mix of work, study, socialising, and a growing awareness of global events. She had never been in trouble with the law, no criminal history, not even a parking fine that she could recall. Her engagement with politics had always been through discussion, online petitions, and the occasional rally, believing passionately in a fair go for everyone. A principle deeply embedded in the Australian psyche. The idea of being labelled a potential threat or having her movements curtailed by police was entirely foreign to her experience. Yet here she was swept into a legal maelstrom simply for exercising her right to express an opinion. A right many Australians take for granted. The streets of Sydney, where she had spent countless hours with friends attending concerts or simply enjoying the city's energy, had suddenly become a forbidden zone. A geographical boundary imposed by a system she was only just beginning to understand. The incident that dramatically altered Siena's life occurred during a period of heightened international tension, leading to protests across major Australian cities. When Israeli President Isaac Herzog visited Australia, a series of demonstrations were organised in Sydney's CBD. Siena, like many others, felt compelled to attend. She believed strongly in the cause, joining the peaceful assembly to voice her concerns. On a particular day, as the protest unfolded near the Sydney Opera House, the atmosphere, while passionate, remained largely peaceful. However, as the crowd dispersed, police began making arrests. Siena was amongst those taken into custody. She was charged with attending an unlawful protest. The charge itself was a shock, but what followed was even more impactful. When granted bail, the conditions imposed were severe. They stipulated that Siena was not to attend any unlawful protests, a condition that on its own might seem reasonable to some. But then came the kicker: she was also prohibited from entering the entire city of Sydney local government area except for attending work or court. This wasn't just about restricting her from future protests, it was an effective ban from a significant portion of the city where she worked, socialized, and simply existed. The imposition of such broad geographical restrictions on a young woman with no prior offences for an alleged offence that was still to be proven struck many as disproportionate. It wasn't just an inconvenience, it was an intrusion into her daily life, a form of punitive, preemptive control before any guilt had been established. The sense of unease of being watched and restricted was palpable for Siena. Her once carefree access to the city's heart, to places like Circular Quay, Hyde Park, or the cultural institutions she loved, was suddenly gone. It was a tangible loss of freedom, a stark illustration of how quickly individual liberties can be curtailed when the wheels of the justice system begin to turn. Immediately Siena and her legal team led by her lawyer Wael Scarf recognized the gravity of these bail conditions. They were not just inconvenient, they were fundamentally unjust, infringing on her basic rights and disproportionately impacting her life. The application to vary her bail conditions was lodged with the Downing Centre local court, the very place where her initial charges were laid. The arguments put forward by Wael Scarf were compelling and multifaceted. He contended that the blanket ban on entering the city of Sydney was not only unduly harsh but also lacked a reasonable nexus to the alleged offence. Siena had no history of violence, no record of failing to comply with previous orders, and no indication that she posed a threat to public safety beyond participating in a protest. To exclude her from such a vast and central part of the city, which is home to so many aspects of civic and cultural life, went far beyond what was necessary to ensure her attendance at court or to prevent further alleged offences. The defence highlighted the principle that bail conditions must be the least restrictive necessary to achieve their purpose, not a form of preemptive punishment. They also underscored the importance of the right to protest, a fundamental aspect of Australian democracy, enshrined implicitly in our common law and recognised in decisions regarding freedom of political communication. What was at stake here wasn't just Siena's individual freedom to move through Sydney, it was about setting a precedent for how the police and courts could restrict citizens based on alleged non-violent protest activities. Could any Australian without a criminal record suddenly find themselves banned from their own city simply for expressing an opinion? The court listened intently, considering the broader implications of such restrictive conditions and how they balanced against the presumption of innocence and the cherished Australian concept of a fair go. Ultimately, the judge's decision was a clear victory for Siena Hopper and more broadly for the principles of individual liberty in Australia. The court found that the bail conditions, particularly the exclusion from the City of Sydney, were indeed not reasonable. The judge overturned these specific restrictions, meaning Siena was once again free to enter the CBD, attend protests, and move about her city without the heavy hand of the state dictating her geographical limits. While the charge of attending an unlawful protest remained and would still need to be addressed at a later date, the immediate burden of the disproportionate bail conditions was lifted. This wasn't a total exoneration, but it was a crucial win on a fundamental point of principle. The outcome underscored that police powers, even when exercised in the interest of public order, are subject to judicial oversight and must be proportionate and reasonable. It was a reminder that the courts act as a vital check and balance, protecting citizens from arbitrary or overly restrictive state actions. Siena regained her freedom of movement, but the experience undoubtedly left its mark, highlighting the often stark reality of navigating the legal system as an individual. The specific dollar figures involved here weren't monetary compensation, but rather the invaluable cost of lost freedom and the psychological toll of being constrained. Justice in this instance wasn't about a payout, it was about the restoration of a basic right. This case serves as a powerful reminder for all Australians about the delicate balance between state power and individual rights. If you find yourself in a similar situation, arrested during a protest or facing bail conditions that feel overly restrictive, it's absolutely crucial to understand your rights. Firstly, the police can impose bail conditions, but these conditions must be reasonable and necessary. They cannot be punitive. The judge's decision in Siena's case highlights